So today we're going to go over Section 101 update. What can we learn from the recent patent eligibility cases and guidelines? As you may recall, we're going to get into this a little bit more, there's been a variety of guidelines that have come out from the USPTO. And there were a couple summary type things that came out earlier this year and that have been updated throughout the year. So we'll kind of get into those and some of the information that's available for you if you're practicing in this area. Just a brief disclaimer that these information I'm giving here today in this presentation is just for educational purposes, and in no way is it legal advice. I've heard a number of people give these disclaimers and say it's for educational and entertainment purposes, but I think those people are far more funny than I am, so I don't put the entertainment purposes in the disclaimer. Anyway, just kind of looking back here at the state of the law on Section 101 and patent eligibility. If you're in this CLE, there's a good chance you are familiar with some of the paths that have gone on and some of the cases and decisions and the highs and lows of this practice area. You can see here, sometimes I feel like it's kind of like this roadmap. You go here and then, oh wait, no, turn here and then try this and try this. This case came down, claim it this way. This case came down, don't claim it that way. So kind of walking through those, we had Mayo versus Prometheus in 2012. After that, we had Association of Molecular Pathology versus Myriad Genetics in 2013. Then there was Alice. And then they had the PTO entered some interim guidelines. After the interim guidelines, we had a little bit of hope because we had DDR holdings thinking, oh good, maybe some cases dealing in the software area can actually get through, are patentable. Unfortunately, DDR was the only case for a long time in that area that did obtain a patent. 2015, there was updated guidelines walking through some of the cases, more examples, criticism on the prior examples that the USPTO had provided. There was another update again in 2016. And then we had InFish and Micro, both of which gave us some light, and a light at the end of the tunnel and a little bit of hope. And then there's been various USPTO memorandums regarding a lot of these different cases. Why was the patent claims in NVIDIA patentable, and how should examiners construe claims in light of that? Contrasting that with other cases where claims haven't been considered patentable. And then we had Ariosa versus Sequenom, and then this year we've had some updated guidelines, which really haven't been necessarily full-out guidelines. There's been some minor revisions to some of the guidelines and examples, but mostly it's been compilation of information to try to provide guidance to applicants. And so that can be helpful, right? So we're going to kind of go through some of this. I'm not going to focus as much on some of the historical things as much as trying to keep this to be more of a current case law examination. So just for context, I was thinking about it. It seems like Mayo came out yesterday. I remember being at my law firm when it came out, and I work in the chemical biotech practice group, and so we have a lot of people who are patenting in this area and writing applications in this area, dealing with medical diagnostics or other genetic related technologies. And I just remember everybody being like, whoa, and to start thinking about your docket and all the cases you have that are in this area where clearly there's something very significant going on in research, right? You have some significant developments identifying correlations in Mayo between the metabolites, the 6-thioguanine metabolite, and potential drug response and how that affected autoimmune diseases. And that's a huge breakthrough in research. And then you have somebody coming down and saying, wow, that's despite the big breakthrough and how helpful it is for people, the way these patent claims are drafted and what you've identified is not actually patentable. And I was thinking about it, I was like, man, I can't believe it's been 5 years since that. So I thought I'd just throw a couple of these older cases that provide context up there just because it's been a long time since maybe some people have encountered them, or if you work in the software area, maybe you forgot about, or you never knew the details as much about Mayo and Myriad, and vice versa if you work in the area of biotech and genetic inventions or diagnostic methods, maybe you're not keeping up as much with some of the software cases. And there is the case law developed out of this string of cases, just in overlapping technology areas or totally distinct technology areas. So just kind of wanted to put this up here and walk through it. You know, basically the facts were that you had this correlation that was identified with this metabolite in the blood, and if you administered a drug in response to achieve a certain desired value for that correlation, it could benefit autoimmune disease treatment. The claims were specific to that correlation, to methods of administering based on that correlation. And when the Supreme Court took up the case, they looked at it and they said, well, the correlation is really a law of nature. I probably should have started with that. I probably should have had Section 101 slide up here to say, you know, what are things that are patentable and what are things that are excluded? Well, laws of nature, abstract ideas, pure mathematical formula are not patentable. I think everybody here probably recognizes that. So the correlation, the court said, was a law of nature, and thus, if you're just claiming the law of nature, you're not really inventing something, you've just identified something, is how the court took it, or wrote it out. You know, and you go back to that and you think, I can kind of see that. It's frustrating because there's still a lot of innovation going on, years and years of research, a lot of money involved in investing in the research and development. And there's going to be some really great things that come out of it for patients. So looking at the claims, they said, well, do the claims do significantly more than describe these natural relations? And before, when you go back to the old 101 cases, you didn't have these kind of questions of significantly more, or is there inventive concept as much. The cases tended to be a little bit more black and white on, well, does it fit into one of the criteria in Section 101, or is it one of these excluded areas? And you'll see that this developed, the significantly more, the inventive concept developed, and now we're kind of at the place that we're at now, which some people criticize as overlapping with obviousness, like looking at, well, is it obvious to arrive at this invention? We'll get into that. So the next case I'm going to highlight is Alice. Everybody may remember Alice was a patent, the Alice case dealt with a patent dealing with settlement risk and mitigating settlement risk. It was kind of a business method patent. And the court examined it under Mayo's first prong there, saying, is it directed to one of the excluded subject matters? You know, is it a law of nature? Is it an abstract idea? Is it a mathematical formula? And the conclusion was, yeah, it is kind of an abstract idea. It's not something completely tangible. So then they said, well, does it do something significantly more? And in assessing that, the court looked at it and said, not really. You know, it seems to be implementing just kind of generic, unspecified computer steps that at this point are pretty well understood in the art. And so they threw out this term inventive concept and said the second prong is looking at, well, are you taking a law of nature or an abstract idea or something excluded, not limiting people from using that in its entirety, but are you doing something inventive with it? And in this case, they said they're not really doing something inventive with it, and they use that inventive concept language. And you can see that here. We've described step 2 of this analysis as a search for an inventive concept that is an element or combination of elements that is sufficient to ensure that the patent in practice amounts to significantly more than a patent upon the ineligible concept itself. And so you can see that transition going from the significantly more to, well, what's an inventive concept? And so we've got this 2-step patent eligibility analysis that came out of these two cases. And you know, the first one really asks, are the claims directed to an excluded subject matter? So, you know, a lot of the cases we're going to deal with are law of nature cases or abstract idea cases. Pure mathematical formulas and other criteria that could fall into that excluded subject matter. And then you ask, do the additional elements in the claim transform the nature of the claim into something patent eligible? And the two, you know, little taglines there from Mayo is, does it provide significantly more? And in Alice, does it provide an inventive concept? Or not just provide, but really, are you claiming significantly more, and are you claiming an inventive concept? And we'll see that as the cases go on, that people want to, at times, people who had patents that issued pre-Mayo, pre-Alice were trying to support validity by arguing, well, look at the specification, you can see more, you can see the inventive concept. They're kind of caught in a rock and a hard place there. So jumping ahead now, as this topic is an update on more recent cases. I think we've spoken about this maybe in 1 or 2 CLEs through the Bar Association, IB Section Council already, the NFISH case, but it also provides some helpful context for the cases that come after and the more recent cases from this past year or so that oftentimes, particularly in the software, business methods, electronics area, cite back to NFISH. So NFISH sued Microsoft for patent infringement. And what was at issue were these databases, these software databases that were self-referential, and they had a unique data structure dealing with this self-referential, ability, and that was all defined by a 4-step algorithm. Now, the 2 patents, you can see the numbers there if you want to look them up, and the claims used means plus function language to define the structure and the function of this self-referential database. And it said, I want to say it's a system for configuring, and then it was a system for configuring, or a means for configuring, a means for configuring, and the means for configuring as defined by the specification was this 4-step algorithm. And then there was also a means for indexing, but the algorithm is largely what the court focused on in that case. Microsoft challenged the validity of the patent, not surprisingly, said, well, not very many patents are surviving in this area, let's give that a go. And the district court said, yeah, all the claims are invalid under 101, held that they were directed to an abstract idea. Under the second prong, there wasn't substantially more. The Federal Circuit took it and said, took it up on appeal and said, well, are the claims really directed to excluded subject matter? And I think what surprised a lot of people was that the court said, no, they're not. They're directed to an improvement in computer capabilities. And that is sufficiently defined by this algorithm in part and by this means plus function claiming. And the court held that the claims were valid. So the takeaway that I think a lot of practitioners took from NFISH was recite more structure, have more sufficient structure, even in your software-related patents, define more structure to connect it with hardware and provides more structure as opposed to this abstract idea of communicating, relaying a signal, storing data, taking an action, something that's purely implemented by computer steps, but actually provide something a little bit additional to that. And then the other takeaway from it was that in this case, this 4-step algorithm did provide sufficient structure to overcome this abstract idea exception, which was a good thing. So for those of us who have applications pending or are prosecuting applications, we have algorithms and we're trying to find a way to get structure kind of defined so that we can get over this 101 issue. Maybe the algorithm is going to be helpful, provided it's sufficiently defined in the specification. So next case that came down, or not the next case, but one of the other next cases that came down was Bascom Global versus AT&T. And Bascom sued AT&T for infringement of this patent. And AT&T countered with a 12b6 motion saying there's failure to state a claim upon which relief can be granted because your patent's invalid under Section 101. And I put this little web page blocked snip up here because that's the technology that was at issue. It was a patent related to internet content filtering, providing customized filters. So it's not just for malware. Maybe a lot of places historically wanted to try to prevent malware or viruses, risky websites. So you might have blockage for that. But then a variety of other businesses started changing what they wanted to prevent employees from accessing. Maybe it was games, or maybe in this case you can see it's actually Bass Pro Shop. It says the category is adult mature content weapons sales because it's Bass Pro Shop. And I'm sure a lot of people who worked at different places have gotten these. Sometimes you're going to a website you need to go to and you get a web page blocked. And you're like, why is this web page blocked? But anyway, there was an issue where a lot of businesses were trying to have customized filtering. So maybe they want to prevent you from going to games, or maybe they want to prevent you from going to Bass Pro Shop. I don't think intentionally. I can't imagine intentionally they want you at Bass Pro Shop, but it just got kind of lumped in based on these keyword searching and identified it with weapons. And so what the history of it was that you used to have to install physical devices on the computer in order to physical software and hardware mechanisms in order to do this customized filtering to provide the ability to customize it at a later date. And Bascom had come up with this method and system for doing this without having to do any of that pre-loaded software hardware on the computers. You could do it just right over the web, which was obviously really great, and then fully customizable later, so businesses could get it easier. They could implement it on their existing computer systems without having to have a technician come in and physically install it on each unit. So that's kind of what was going on. And AT&T was providing this filtering as a service to some of its customers. So the court, in looking at that, the Federal Circuit looked at it and said, are the claims directed to excluded subject matter? And they said yes. Just generally, the idea of filtering content is abstract. And what they said here, which I thought was interesting, is they said because it is a long-standing, well-known method of organizing human behavior. And so that's why it's abstract. And what you'll see when we go to these later guidelines that have been coming out this year is that the USPTO has created 4 categories of abstract ideas, and they've given you listings of cases on how those, so you can look at how those were applied and why they fell into those categorizations. And there's a possibility that you may need to do different things to try to overcome that rejection based on the classification, or it may give you an idea as to what kind of claim limitations you may need. So it's a helpful tool, and we'll get into that in more detail. But that's part of the reason I highlight this well-known method of organizing human behavior. Bascom countered, well, that it's not abstract, and they focused on 2 claims, Claim 1 and Claim 23. And you can see here they made kind of an expected argument regarding Claim 1, saying, no, it's directed to a really specific problem, and it's got a really big benefit, and trying to hype up this inventive aspect of it and say, no, it's more particularized than you're giving it, and it's solving a big problem. So it's not really abstract, it's pretty concrete, actually, when you look at the problem and you look how tailored it is to that problem. The court did not agree with Bascom's argument regarding the first prong in abstraction. So the Claim 23, though, had more structure associated with the system. And so Bascom said, oh, hey, let's try to use what NVIDIA did. Maybe we can get some compatibility out of that. So they argued that Claim 23 is directed to an even more particular problem of structuring a filtering scheme, not just to be effective, but also to make user-level customization remain administrable as users are added instead of becoming intractably complex. So they're saying, look, there's this whole filtering scheme that's there. It allows for user-level customization. There's a lot of different levels of system structure that have to go through for that to be possible. And you let NVIDIA was patentable for similar kind of reasons. We're pretty analogous to that. But it didn't persuade the court, and the court said, no, it's directed to an abstract idea. So they went to the second step and said, do the additional elements transform the nature of the claim? Is there an inventive concept here? And the court held there was. The inventive concept transformed the abstract idea into something patentable. And here's 2 little notes of things that they had kind of summaries of what the court had said. They said, when taken individually, many of these limitations regarding the structuring scheme, filtering, all these limitations were kind of generic components, none of which was invented by itself. But the way that they ordered those was, because it gave a specific location for filtering a system and required the filtering system to give users ability to customize the filtering. And that had not been done before. And it was specific enough that it wasn't just an abstract, anybody can filter at any time in any manner, kind of, this big concept. It was very specific and tailored to individual time periods, and they had to describe sufficient structure and claim sufficient structure to actually allow that to happen. So the court said it was patent eligible. So those are 2 of the cases that happened in 2016. The rest of my presentation is going to focus on 2017, just because I think a lot of these cases have been talked about throughout the bar pretty regularly in the older cases. And I'm happy to talk about some of those cases if people have questions about the older cases afterwards. Anyway, moving up here, April 2017, the USPTO released some additional guideline summaries. And they did two things that they released. They released a quick reference sheet, which categorized a lot of these different cases into abstract idea, law of nature, like what exception from patent eligibility did the different cases fall into. And it's a nice chart. I show some copies of it coming up here, but it's color-coded and kind of helpful. And then they also looked at, with respect to abstract idea, these categories of what kind of abstract idea is it? Is it like a purely financial abstract idea? Is it the organizing human behavior kind of abstract idea? They did that, this quick reference sheet, which is nice. And then they also did a compendium of patent eligibility cases going back to 1979 through the current year. And that was pretty nice. If you go to the website on the link there, and you can, I should make a note of that. If you go to the handouts portion of the GoToMeeting, you can download a copy of my presentation in PDF form for your own reference and keeping, and you can use this this hyperlink, which takes you actually to all the historical memorandums, all the historical guidelines, discussion of those things, and a variety of other useful resources at the USPTO's website, part of which is this summary. And so this compendium of eligibility cases, if you download it, it's an Excel spreadsheet, so you can sort it and organize it in a variety of ways. There's a lot of information in there that's pretty useful, kind of walking back through some of the historic cases, you know, Diamond versus Deere, Chakravarti, as well as the most recent cases. Anyway, in October of this year, they actually updated the reference sheet again and updated the compendium again, which I have a little story about that here in a moment. But this is a useful resource, and so we're going to kind of walk through what some of that information is, just to give you guys a sense of what kind of tools are at your fingertips and how the USPTO is looking at these cases. I think that's another helpful aspect of it, because it helps inform us as to what the examiners are also looking at. You know, what kind of training materials they have and how the office is portraying this particular area to the examining corps. So here's the quick reference guide. I've snipped a couple pages of it for you guys to look at here. I don't have, there's 3 pages. The last one was very large, and so I didn't do that. But you can see here, claims eligible under Step 2A. And so they've separated them out under, like, why are the claims eligible and which ones. So it's not directed, on the left there you can see not directed to an abstract idea. And that's where you look at DDR holdings, NFISH, fails case, micro, visual memory, which we're going to discuss here. Then claim that is not directed to a law of nature or natural phenomenon. And you've got your cases there. And they make a note in these too when the USPTO has additional documents related to the cases if you wanted to look at them. So like, say, for example, the DDR holdings, that corresponds example 2 to their examination guideline examples. Similarly, the NFISH or the Rapid Litigation Management versus Cells Direct both reference USPTO official memorandum on those cases and how to examine and prosecute cases in light of those. So you can see that there. And then on the very right, we have the product of nature, kind of looking back, all the way back to Chakravarti, but then also looking at myriad later case. So in some of the examples there. Going here, the next part of it was claims eligible under Step 2B. So just in reference to Step 2A and Step 2B are references to the 2-prong Mayo-Alice test, right? So the first one, is it directed to excluded subject matter? Going back a page there, you know, no, it's not, because it's not an abstract idea, or it's not directed to a law of nature, or it's not directed to a product of nature, is the idea with those. And then here it's saying, okay, well, these are cases where the claims were found to be directed to an excluded subject matter, so they were directed to an abstract idea or a law of nature, but there's significantly more. There's an inventive concept under the second prong, and so these cases were found eligible under that. So there's some brief information again about what kind of case they are. You know, McKay Radio deals with an antenna. Deere, you know, old case there goes back to rubber manufacturing, and then they again reference corresponding examples in their own materials. So if you wanted to look up that case and see how the USPTO is training the examiners for why it's patentable, to try to see as much as you can analogize or mirror the prosecution of your case that may be in a similar technology area, you kind of have that as a resource. And that is pretty helpful, I do think, because I think the examiners are getting these memos, they're getting the example sets, they're getting the examination guidelines, and they're getting training on those things and being told this is how you need to examine applications, and they are looking at it. Now, it's not in all instances, it doesn't necessarily, it's not like a green light or something, excuse me there, a green light for patentability necessarily or an allowance, but it is a helpful tool because the examiners are familiar with those examples, generally speaking, many of them are, and they're familiar with these memorandums too. So if you can walk through a case and say, look, we're more like example 4 than we are this other example that wasn't patentable, and analogize why and show what claim limitations you have that are similar and provide, the significantly more inventive concept or why your claims are not directed to an abstract idea, then you're better off in that prosecution. Doesn't mean it's not hard still with a number of applications, but that is a helpful way of doing it. So the last portion, as I mentioned with the quick reference guide, is that they broke down abstract idea into 4 different categories. And so they have, one category is the idea of itself, and they have a nice listing of all of the cases that fall under these. So I mean, that's part of the reason that I did not copy that page here, but if you go to that website, you can get it. Because I mean, some of them are really large and have like a lot of listings of cases. So idea of itself, they give an example of Myriad, because Myriad was comparing information regarding a sample of a test subject to a control or target data. As you may remember, Myriad is the case dealing with the BRCA1 and BRCA2 genes, right? So you have a specific genetic sequence that you're looking at in a control sample, and you're saying, do you have this mutation, yes or no? And you're comparing it with a patient for diagnostic purposes. So that's why it's the idea of itself. That seems a little abstract to me as a definition, but anyway, that's how they're classifying that category. Certain methods of organizing human activity. Remember we talked about that. Bascom, filtering internet content. It's a way of organizing human activity. We do want people going to this website. We don't want people going to this website. And there's steps being taken to prevent that. Are those generic steps already well known, or is there something inventive? Fundamental economic practices is the 3rd category. And 2 examples that I highlighted there is Alice with mitigating settlement risk, and Bilski for its teachings on hedging. And what's interesting is that they broke apart Bilski, some of the claims. I mean, it's not terribly surprising. When we draft claims, we draft them with different scope. But yeah, so hedging, the fundamental economic practices encompass Bilski's claims 1 through 3 and 9. And mathematical relationships and formulas is the 4th category, and that encompasses claims 4 through 8, 10, and 11 of Bilski, because Bilski at that point was claiming hedging based on a specific mathematical formula, as you guys may remember. So those are the categories, and like I said, it's a good resource because if you can figure out what category you're falling into an abstract idea, or if the examiner hopefully has called it out saying, this is an abstract idea because it is a known method of organizing human activity, or it's a mathematical formula, then you can go to that sheet and you can look at those cases and you can walk through them and say, okay, which cases were successful here recently, and what have been the arguments made, the claim limitations amended in to get over these, or if they weren't amended, if these cases were coming out of a litigation, what did the court talk about? Why was it valid or why was it invalid? Try to use this as a tool. So earlier I said that the USPTO had updated the April data for October at the end of October. I did not know that. And so I was looking at that and thinking, oh, this is a great resource. I hadn't been to the website in a little bit. I knew about it. I was like, I'll just kind of try to update it and cover cases from the last 6 months or highlight some of those, since the prior one had been published in April. I thought, oh, that'll be good. I can give you guys something useful you can use. So I spent some time on Westlaw, finding the cases. I pulled out ones that referenced 101 but weren't really dealing with 101, and I added an additional one up there, Mastermind, which is actually not a 101 case but dealing with definiteness, and you'll see why. Anyway, I thought, oh, this will be really good, and then I went back to the website for the guides and saw that they'd updated it in October, and so I really didn't need to create this table because I could have just got the one from the Excel file at the USPTO. But anyway, just kind of showing you this table here. This is the last 6 months of cases dealing with 101 mostly. You know, at least ones I want to highlight here. We're not going to talk through all of them because that's a lot of cases, but we are going to talk through some of them. You can see the technology area, the case citations. Some of them are too new to actually have citations. And was it considered eligible? No. There's really, in the last 6 months, there was only one dealing with the natural law in the diagnostics area, and that's the Cleveland Clinic case. So we definitely will talk about that. But for those of you who are working in the biotech, medical diagnostics areas, sorry, a lot of the cases that we are going to address are going to be more software, computer related, just because that's the cases that we've had in the past 6 months. And then the one that I have bolded there and in green is the one that came out of everything as patent eligible, visual memory, and we're definitely going to talk about that. And then lastly, we'll also talk about this Mastermind case, which is the definiteness case. And you'll see kind of why that's important, even though it's not directly dealing with eligibility at this time. I haven't read all the pleadings in that case, but I'm wondering if there will be some issues, some questions and challenges regarding patent eligibility as well. So the Cleveland Clinic case, we're going to go in order of when the cases came out. So this is the oldest of the cases from the past 6 months we're going to talk about. Cleveland Clinic owned a family of patents, and they were all highly related patents, and they're dealing with myeloperoxidase and correlating that with the risk of cardiovascular disease. And so what they figured out is that if you had a certain amount of MPO activity, or if you had a certain level of MPO mass in your bloodstream, that there was a higher chance of cardiovascular disease within a certain time period. And so they had these 3 patents directed to testing panels, and this last patent directed to a method of treating a patient. And they were using this correlation to treat people for possibility of cardiovascular disease. So here's, if you were curious what MPO looks like, there it is. It's an enzyme. And like I said, they're testing the level of MPO activity, or they're testing the mass of MPO from a patient. And then they've taken control samples from patients who do not have cardiovascular disease. And they've stored those, and they've made a database of those. And they're testing the MPO activity or mass against those controls for people who are known to have sufficiently low MPO level or mass, but they're not having cardiovascular disease from it. So elevated MPO activity or mass indicated a risk for a cardiovascular event, and so then they would treat that patient by administering a lipid-lowering agent. So as I mentioned, the first 3 patents are dealing with the actual correlation and the tests themselves, whereas the 4th patent was dealing with a treatment. What's interesting is that the treatment patent actually issued after the Mayo Alice decisions, and I talk a little bit about the timing of in here as well, because I think that's an interesting thing that occurred with these patents. So what had gone on is that Cleveland Clinic had these patents issued, and they had used True Health Diagnostics to make and sell tests for assessing the MPO and a cardiovascular risk for doctors. Eventually, True Health said, we're not going to pay this license anymore, and they're done. And they went out and just did it on their own. I haven't read all the details of what went on between the parties, but I assume that they thought these aren't eligible in light of Myriad, and so why continue to pay for it? We've got a good defense here. But I don't know. That's my hypothesis. So Cleveland Clinic sued them for infringement and moved for a preliminary injunction, saying they've got to stop now. They're injuring our sales because these are the guys who are selling and distributing for us. True Health then filed a motion to dismiss, saying the claims and all these patents are directed to patent ineligible subject matter. And the district court agreed, held that the claims were invalid, and dismissed the case. So it got appealed to the Federal Circuit, and the Federal Circuit said, applied the Mayo-Alice test and said, is this directed to excluded subject matter? And the answer was yes. It's a law of nature. This correlation between NPO activity levels or NPO mass and cardiovascular disease. It was highly analogous to the Mayo case, where you're looking at an amount of a metabolite level, correlating that to autoimmune disease and treatment of autoimmune disease, and figuring out that you want a certain amount of the drug metabolite in your system, or the drug in your system, you can measure that based on the metabolite. So you can then administer the drug in response to that. So in light of that, they said, yeah, it's an abstract idea, or it's a law of nature. So move on to step 2, and the court said, well, are there additional elements to provide significantly more, or to provide the inventive concept? And the court held no, it was not transformative. And they noted that the researchers had identified an important correlation in nature, and not to undermine the research and what that meant to treatment of heart disease and for people in this medical area. But they said essentially, you've identified a law of nature, this correlation, and the remaining steps that are there, comparing the level to a control level, and then making a decision about providing, a lipid-lowering drug and possibly administering that, was not transformative. It was generic and routine in the medical field, or in this particular art. So the Federal Circuit granted the district court's motion to dismiss. And I think the takeaways that we can have here, that correlation, again, we go back to that Mayo decision. Correlation is not sufficient to get you over abstract idea. We really do need to be claiming more. The hard thing for Cleveland Clinic is that they had a couple of these patents had issued before Mayo. So the first 2 were issued in 2007 and 2008. Mayo came down in March 2012. And Cleveland Clinic, for their 3rd patent, paid the issue fee in December 2012. And it got a notice of allowance, I want to say, in, I think it was September. I'm pretty sure they paid it around 3 months. So they had a little bit of time there where it's interesting that they got that 3rd patent allowed in light of the Mayo case, but it was still early before, Myriad had come out, before Alice had come out. But the last one there, you can see that the method of treating, or an individual, actually issued in 2015, which was kind of surprising to me that they've been able to get that case allowed in light of particularly the Mayo decision. But at that point, it was a totally different dynamic in the medical diagnostics area for claiming and allowability. So it's interesting they got that. But regardless, those first 2 patents, you kind of stuck in a rock and a hard place. You had patents that were valid, considered valid. Technically they're considered valid until found invalid, but really after the Mayo decision, people might have questioned that a little bit, but they were trying to find a way to argue that, and the court said, no, it's not transformative enough. So got to have more than just claiming a correlation and administering something based on it. So visual memory is one of the cases that the USPT, or that the Federal Circuit did find was valid under Section 101. And visual memory sued NVIDIA, the graphic card designer, or graphic card company, and they do a variety of other things as well in that space. And the patent was directed to an improved computer memory system. NVIDIA then said, okay, well, we're going to move to dismiss this for failure to state a claim, as your patent that you're making your claims upon is invalid under 101. And the district court held that it was ineligible. So it went up to the Federal Circuit, and the Federal Circuit said, well, are these claims directed to excluded subject matter? And they actually said, no, they're not directed to an abstract idea, which is what the district court had said. And the Federal Circuit, I got some quotes here from the Federal Circuit opinion. I don't want to just read everything to you, but you can see here they talked about some of the things that changed it. One, looking at that second bullet point, none of the claims recite all types and all forms of categorical storage. So it's not this broad encompassing everything. You're providing some specificity as to where your actual improvement is, what type of data, where that data is. And then they said that the specific asserted improvement uses these programmable operational characteristics that are configurable based on the type of processor. And they said based on that, this is not an abstract idea because you've actually identified, I think, some structures, some hardware, this processor. It's a specific type of processor. It's not just generically claiming, a lot of people want to try to claim such broad things. Well, this could be modified to work with these processors or these processors or these processors. And they focused in on what can we do, what does this data go with, what type of processor does this work with? And the court said they had enough specificity to it that it wasn't an abstract idea. It was specific. It wasn't just any kind of data. It was specific kind of data, and it was specifically tied to certain processors. So visual memory survived the first prong. It didn't have to go to the second. Next case we're going to discuss is two-way media versus Comcast. And two-way media had a family of 4 patents dealing with streaming audiovisual data over the internet. And they sued Comcast and Verizon for infringement of those 4 patents. All 4 of the patents were related, so they shared the same specification. So a lot of the issues you were dealing with there were pretty similar. I think when you go back to the Cleveland Clinic's cases, there were some changes in that specification. There was a CIP filed at one point, so there were some differences, I think, with respect to ultimately the case claiming the method of treatment, maybe. But anyway, this case, they were all the same specification. So I wanted to provide an example claim here to kind of look at it. We're going to contrast this because I'll give this away right now for those of you who don't know. But two-way media did not survive the Mayo Alice test. Their claims were held to be invalid. And so I want to walk through some differences that we can glean between, say, two-way media and NFISH, and say what is it that is getting somebody to allowability, in these claims in kind of similar areas. So you have a method for transmitting message packets over a communications network comprising these steps. I'm not going to read them all, but you're converting a plurality of streams. For each stream, you're routing the stream to one or more users. You're controlling the routing of the streams, response to signals, and then you're monitoring the reception of packets by the users and accumulated records, right? So there's this step of converting and routing and controlling and then monitoring reception, right? So that's the claim. That's claim 1, which is kind of representative of not all of the patents and claims at issue, but it was representative of at least 2 of the patents the court felt, and it gives you an idea of what kind of technology the claims were directed to in that case. So the court then said, are they directed to exclude subject matter? Did the first prong of the Mayo Alice test. And the Federal Circuit cited the micro case from earlier, saying, I don't know if you're really supposed to call it micro, but I call it micro. We look to whether the claims in the patent focused on a specific means or method, or are instead directed to a result or effect that is itself the abstract idea. So that's where we get to that abstract idea itself in that category. And merely invokes generic processes and machinery. So you can see here, the court is saying, are we looking at something where you're just trying to claim itself, a method of communicating a signal and receiving a signal and monitoring that signal is released, or reception, or like generic steps like that, or is there enough detailed out? I know I skipped out some of the detail in the claims, but that's the question they're asking here. Is there enough detail and specificity and structure in the claim? This isn't just an abstract idea of communicating something, knowing if it's been received by whatever's receiving that communication. But ultimately, the court concluded here, no, this is an abstract idea. This isn't something specific like some of the other cases we looked at. Oops, too far. All right. So step 2, the court said, do the additional elements transform it? And there the court said no. It's not transformative. There's not an inventive concept coming out of it. It's generic computer implemented steps. And so that's not going to get you over the Mayo Alice test. So here's the comparison I have. I brought in a claim from NFISH. This is claim 17 of the 604 patent. The court thought that that was representative of the patent claims at issue in the NFISH case and put it in its opinion. And similarly did the same thing with claim 1 of the 187 patent for two-way media, at least with respect to the 187 patent, and I believe this the 005 patent. And you can look there. We just looked at the two-way media claim where we had the converting the streams, routing the streams, controlling the routing of the streams of packets in response to selection signals, and then monitoring the reception of packets by the users, right? And then the other case here where we have NFISH, which was patentable, we've got that means for configuring limitation, set memory according to a logical table, said logical table including plurality of logical rows, each said logical row including an object identification number, excuse me for the break there, to identify each said logical row corresponding to a record of information, and then a plurality of logical columns intersecting said plurality of logical rows to define a plurality of logical cells, each said logical column including no ID, the object identification number, to identify each said logical column, and means for indexing data stored in said table. And so you can see there, I probably should have put that up on the NFISH slide as well, what the court was referring to when it talked about sufficient structure being provided in the NFISH claim. There's quite a bit of structure, relationship between the different rows and the logic behind everything. And then the other part of this system claim is that you have this means for configuring, which has a very specific four-step algorithm that's being applied. So you can see the difference between those two claims, not making an opinion myself of whether I think two-way media should be or shouldn't be patentable, but just you can definitely see the difference between the claims and the amount of structure recited in the one versus the lack of structure and specificity recited in the two-way media claim. So in finding the NFISH claims patent eligible, the means for configuring clause was important here. The court said that the claims are not simply directed to any form of storing tabular data. It's not abstract like that. It's not general and vague, generic, but rather it was this self-referential table, and they defined enough of the structure for how that self-referential table worked in the claims that they could then rely on the means plus function to provide the additional limitations that they really needed for having that eligibility, having sufficient structure. So kind of, yeah, the takeaway there is when you're fighting the abstract idea, particularly of that category that the USPTO has identified of the idea itself, having more structure can be helpful. And I think a lot of people here may recognize that already, but you can see that trend continuing through the cases. So what's interesting then, and I put this up because this looks like a lot of actual physical structure to me, and you have this problem of running into overcoming eligibility to becoming indefinite or dealing with an indefiniteness rejection. And that's why I brought up the indefiniteness case that recently came down, because some things that have been happening is a lot of these claims are directed to methods, right? Possibly systems, but also methods. Or sometimes you've got a system claim, but there's certain ways of using that system that provide some of that specificity that you need, right? So you end up with prosecution, you've got a 101 rejection where you've got a method claim set, and you think, I need to recite more of the structure behind this so it's not just generic steps of performing the method itself, right, to get away from that abstract idea. So you add in some structure, system claims or something to that effect. Vice versa, you have a system claim and you've got that laid out, but you end up needing some steps that kind of walk through how the method works, right? Permissible functional language, something to that effect, saying, this system is configured to do this or receive this response and take this action, so that you can provide enough specificity to get over this abstract idea, generic language rejection that you deal with. But what's been happening is this has resurrected a 2005 case, IPXL Holdings, which talks about indefiniteness, where you are claiming two different classes of invention, a system class versus a method class, right? So in IPXL Holdings, which is a federal circuit case from 2005, obviously dating before the changes in subject matter eligibility cases, you had a lot of claims in this case which were directed to the system for executing electronic financial transactions. And most of those claims were directed to the system were found anticipated. One claim that was not found anticipated was Claim 25. And so the Federal Circuit looked at that claim. Ultimately, it depended back from Claim 1. But you can see here, the system of Claim 2, wherein the predicted transaction information comprises both the transaction type and the transaction parameters associated with that transaction type. And then here's the critical language. And the user uses the input means to either change the predicted transaction information or accept. So right there you have some sort of method claiming going on. Maybe it's permissible functional language, but in this case, the court held it was a method. It was method, right? And the issue was raised whether Claim 25 was directed to a system or a method. In the preamble, it's a system. Everything else is system-oriented. All the prior claims there, that Claim 1, Claim 2, were clearly directed to a system. But the court said, here this user uses the input means, and so that's kind of method claiming. And so looking at the public notice aspect of a patent claim, the court came back and said it's indefinite because it's not clear for somebody in the public to know if they make the system and they create that system, are they now infringing that system even though a user has not, let's see here, a user has not input or a change predicted or accepted the displayed transaction, right? Those two different steps and possible options. So the court held it's not clear, or is it actually when a user takes those steps and it fails the public notice function, it is indefinite. So that case has been getting resurrected in cases that have been in prosecution. I went out and looked at the PTAB docket, I tried to look mostly for just this year for some cases where this issue came up based on different limitations that were in the claims. And you can see here, this is ex parte done, and this decision came down in January of this year. And the claims were directed to a system for estimating a transaction time. And in a system where there's a lot of different transactions occurring, and it makes it a very complex system. And so the idea is it can identify and estimate the times based on all these different correlated transactions. And then if any of them is going to go beyond the time that's set for it, then it takes a remedial step. The claims were anticipated in that case, and that was the issue on appeal. But the PTAB noted kindly that even if the claims weren't anticipated and they brought this in, there's a good chance that the claims are likely indefinite under IPXL because now they have a limitation claiming a method. And I'll show you that in a second, or a means for use when the claims that are directed to a processor. And here you can see some of those things that they highlighted. Here it is, a system comprising a processor. You've got this configured to initiate executable operations comprising, and then you have determining, calculating, comparing, and implementing. And the court said that it's not clear if this is actually to the system that is capable of doing those things, or if it's to the system actually performing those operations. Another one that came down this year was in May, ex parte Mundra, and these are just some examples. There were other cases citing this definiteness issue. Claims were directed to a system for real-time, on-the-fly data encryption. And the claims were rejected as indefinite, or actually no, excuse me, they were rejected as anticipated and obvious. And then the PTAB came back and said, no, there's a new ground of rejection. They're indefinite because you have a speculative, this is the claim limitation at issue, a speculative crypto operation may be initiated in at least one of the plurality of encryption cores. So this was again to a system, but there's this may be initiated language, and the court said, no, back to IPXL Holdings, that's not going to fly. You're claiming a method and you're claiming the actual system itself. And I'm running short on time here, so I'll move through this case kind of quickly. But this was a Federal Circuit case that came down just recently, October 30th. And this is the one where I mentioned I don't know that there was any eligibility claims made. in response to the lawsuit being filed against Microsoft. Microsoft countered that under IPXL Holdings, the claims were indefinite because they claim both methods and systems. And here, the court actually, the USPTO, distinguished the IPXL Holdings case, saying, look, no, it focuses on capabilities of the system. It's using permissible functional language, and I put that in green because that's the go, right? Focuses on capabilities of the system, not specific actions. Had it focused on specific actions, then maybe you'd be falling under IPXL. But the Federal Circuit distinguished IPXL, noting that the terms presents, receives, generates represent permissible functional language used to describe the capabilities, as opposed to actually performing reception or presenting data or generating some sort of report or something. So the takeaway there is make sure that when you're getting around the Section 101 issues, you want to be sure that you are not walking into an indefiniteness trap in any of these ways that we can kind of see it. So at that point, I'll say thank you, and I'll open it up for questions. I apologize, I'm running pretty close to the end of the hour.
Thank you, Jonathan. Before we get to questions, I'll just go through a few announcements. So you've got a couple seconds if you want to shoot me a question to ask Jonathan. First off, December 1st, e-commerce.
Questions. If not, then maybe it was good timing. I'll give it just another bit, but I want to thank you all for attending the webinar, and want to remind you too again that we do have the IP section council and e-commerce section joint CLE coming up on December 1st. We have a really great lineup of people talking about a variety of pretty interesting things. We've got IP ethics lawyer Michael McCabe, who does defense for attorneys accused of malpractice before the PTO, both the trademark and patent office sections. And that's his practice, working with the OED there. And he's going to provide 2 hours of ethics CLE. He's a really dynamic, fantastic speaker, makes ethics enjoyable, and it's pretty applicable to people working in this area. And then we've also got a variety of other issues, kind of hot topic issues like blockchain and cryptocurrency, to kind of where is the Defend Trade Secrets Act standing now, what cases have come out of that, as that's a pretty new law. And it should be a really great day. The other thing is we're going to be sending out more information regarding our webinar series shortly, as we'll be doing the 2018 webinar series. And right now we've got our February speaker lined up, Matthew Smith from Smith & Baluk, who does extensive amount of IPR practice, very, very experienced there. And he's got a boutique kind of IPR practice firm. He'll be talking on some of the recent trends in IPR practice. That, I should say, that encompasses, kind of post-grant review and some of those other post-grant proceedings. And he'll be great. And then we have other great speakers lined up for the year that we're working on finalizing which dates who is going into. We'll be coming out with that information shortly. So thank you very much for attending.